everyone, I am Romelyn Alba from PCBed 01402A and I am going to discuss provision under Chapter 1. Before we start, let us discuss um, agenda of today's discussion. Under Chapter 1, we have Article 1767, Concept of Partnership and how partnership exists. Second topic will be profession, its definition, the breakdown of it, and some examples. Lastly is the essential requisites of a contract partnership which consists of 5. First, we have the existence of a valid contract, legality capacity to enter into a contract, contribution to common fund, purpose to obtain profits, and legality of the object. Let us now first discuss the provision under Chapter 1, which is Article 1767, which states that with the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. It also states that two or more persons may also form a partnership for the exercise of a profession. Now, let us answer the question how partnership exists. By doing so, let us break down the information under Article 1767 and pick out the keywords. The first keywords we have are person and bind. When we say person, it could either be a natural, which is the person itself, and a juridical entity, which is created by the operation of law. Next, we have the word bind. When we say bind, there is an agreement or a contract that took place among the parties. There are two forms of contract. It could be done orally or in written form. When it is in written form, it falls under the articles of co-partnership, which will be discussed later on the following slides. The next keywords are contribute money, property, or industry to a common fund. First, we have money, property, and industry. These are recognized as non-cash assets that is contributed by the partners itself to the entity, which is the common fund. Common funds are where the contribution of the partners goes into. Since those contributions will be recognized as the properties of the entity itself, but not the owners. There is a thin line that separates the two. Regardless, they have equal rights, or regardless, the partners all have equal rights as they all contributed into the partnership. The properties of the partnership shall only be intended to use as or for profit-making activities and not for personal activities. Next, we have the keywords dividing the profits among themselves. There are instances wherein upon making of an agreement or a contract, the partners indicated the division of profits among themselves. It does not end on the division of profits, but it also recognized the division of losses among the partners. The division will be depends upon the ratio or the percentage of how much does a partner contributed into the entity. It could either be 50-50, 60-40, or 50-25-25. Those ratios are subject to change as the operation of the business. There are instances where new partners enter into the business and thus affect the division of profits. And there will be readjustments for that. Take note that profits that will be gained in the operation shall not be continuously invested, but it should also be accumulated. Yeah. Next, let us now discuss the highlighted word under the Article 17 highlighted sentence rather under the Article 1767, which is two or more persons may also form a partnership for the exercise of a profession. When we say profession, there are a lot of jobs that comes into our mind. Let's say we have doctors, educators, attorneys, engineers, and many others. It is said that these people can form a partnership merely by expressing their profession. Let's first identify what is the definition of profession. It is a group of men pursuing art as a common calling in the spirit of public service, no less a public service because it may incidentally be a means of livelihood. Meaning, in the long run, these exercise of their professions or enhancing their professions may also be a profit gaining activity. In such cases, profits gained through the business operations are divided among the partners. One interesting thing about this is that there is no required capital upon making the partnership since this is created merely with the exercise of profession. Another is that um, partnerships created through professions are not subjected into a tax. The entity itself is not subjected into the tax. Rather, the uh, the owners itself or among they have personal taxes to be paid after distributing the profits from their business operations. Another thing is that the founders of the professional partnership are also called partners. Strictly speaking, the practice of profession is not a business or an enterprise for profit. However, the law allows a joint pursuit thereof two or more persons as partners. That is under Article 1783, which will be discussed by the other reporters. In such cases, it is the individual partners and that the partnership who engage in the practice of the profession, which means any act, act of the owners is responsible for their own, meaning if there is a any problems that may happen in the future, that particular partner who is subjected into that is the one responsible um, for making solutions of that problem, separated from the other partners who is not involved into that activity of the other. Lastly, since this is created merely for the practice of profession, the personal qualifications for this partnership cannot be possessed by a corporation. There are instances in partnership is being incorporated in the future uh, when they generate more profits and wanted to expand their businesses. So the main thing here is that it is true that a partnership can be formed merely by a profession without any capital. A partnership can rise with the name itself and is also binded to the rules of any other partnership. Let us talk about the essential requisites of a contract partnership. First, we have So the first one under the essential requisites of a contract partnership is that there must be a valid contract and it is subdivided into two. The first one is that partnership relation, fundamentally contractual, and partnership relation fiduciary in nature. Let's first discuss the partnership relation. It is subdivided into three. The first one, the form, it could be done orally, written, expressed or implied from the acts, declaration of the parties. These are merely just the consent of the parties upon the agreement of a contract. Next, we have the articles of partnership, which is a contract that forms the agreement among the business partners. It serves as the rule book of limited partners, outlining the conditions under the contract. This should include the following. The first one is the name, the chosen name of the business entity. Second is the nature. It could be in the form of service, merchandising, manufacturing, or hybrid, which is a combination of the first three. And the purpose of the business. In the contract, it should also be indicated the power, duties, and liabilities of the uh, partners. Next, we have the distribution of profit and losses. There are instances wherein in the contract it is already uh, the distribution of profit and losses are already indicated in the form of ratios or the form of percentage. But in such cases that there is no indication, um, profits and losses shall be equally distributed among the partners. Next is the partnership dissolution. Uh, the partners, any of the partner can express his or her will to withdrawn from the partnership, and that effect into the dissolution of the partnership, but one must um, act in accordance with a good faith. I'm going to discuss that under the partnership relation in fiduciary nature as well. Lastly, we have the requisites of a contract. For a contract to be recognized as valid, this should include the following. The first one is the consent among the parties. They all should have a meeting of minds, and the capacity of the contracting parties. When we say capacity, the person should be able to decide for him or for herself. Meaning, an incapacitated person are not or are limited into entering such contracts. This will be discussed later on the following slides. Second is the object, which is the subject of matter of the um, contract, and cause, which is established. The second one, which is the partnership relation fiduciary in nature, it's also subdivided into three. The first one is the right to choose co-partners. Since partnership is a voluntary association which is entered by the associates, it falls under the doctrine of delectus personae. When we say delectus personae, it signifies the choice of a person, and under the right to choose co-partners, unless stated in the contract, one partner cannot take another into the partnership without the consent of the other. The next one, we have power to dissolve partnership. Neither the duration or specified time on the indicated in the contract, nor the purpose of creation of the partnership shall prevent the dissolution of the partnership. Again, under the doctrine of delectus personae, it allows the person to choose. It does not necessarily give a right to dissolve the partnership, but gives the right to express his will. By doing so, it is recognized only when he act in accordance with good faith. Next, we have the applications of principles of estoppel. Uh, it is a part wherein a partnership liability may be imposed upon the principle of estoppel, where a partner can hold himself out or permits himself to be held as a partner in the enterprise. Let us define what is the principles of estoppel. It prevents someone from arguing something or asserting a right that contradicts from the previous agreement or previously said agreement which is under the law. It is used to prevent someone to be unjustly uh, wrong wrong by inconsistencies of another person's words or actions. The second essential requisites is that contribution of money, property, or industry into a common fund. It is the existence of propriety interest. It is subdivided into three, which already indicated here. First one is the money. Money is a medium of exchange or a currency. In the Philippines, we call the medium of exchange as peso. Next, we have property. Property, by its meaning, it refers to any external thing over which the right, possession, use, and employment of a partner. Under the property, should take note that the property should have a useful life for more at least or more than 2 years. Next, we have the industry. Industry are the diligence in the performance of a task or a particular branch of productivity or productive labor. This could be in the form of the skills that can be contributed of a partner into the entity. This could either be their knowledge or skills of the specific uh, thing that will help the entity for its operations. Next, the third essential requisites of a contract partnership is the legal capacity of the parties to enter into a contract. It is said under the requisites of the contract earlier that a person should be able to give his consent and should be able to decide or have the capacity to decide for himself upon the agreement of the contract as well as for the future operations of an entity. Uh, it is highlighted that they should be able to think, decide, and should be in the right mind for them to be able to enter into any of a contract. So the question here is that who cannot give their consent to a partnership? So these are the people or some of the people who cannot enter into any contract. The first one is the unemancipated minors, which are those people who ages below 18, which is the legal age of the Philippines. These are the minors who cannot decide for themselves without the presence of their guardians. I mean, next is the insane or demented persons. Of course, insane persons cannot be able to decide for themselves. They are not in their right mind and they have medical issues. Demented persons are those people who often forgets. Anyway, they still fall under the medical issues. Next are deaf or mutes who do not know how to write. Since deaf and mutes cannot not be able to communicate as any other person should be, they are also not given a consent to enter into any of a contract. Next, person who are suffering from civil interdiction. When we say civil interdiction, these are the people who um, cannot or have not don't have the ability to manage their estate, maybe because uh, they have issues like mental issues and such, or any other medical uh, concerns. And lastly, incompetents who are um, under guardianship. Again, they cannot be able to um, decide without the presence of their guardians. So those are the people who are not uh, or who cannot enter into any of a contract. On the other hand, in instances wherein a partnership wants to enter into a partnership with another partnership, there is no provision on that indicated in the Philippine law. Next, essential requisites of a contract partnership is the purpose to obtain profits. Um, the main purpose of building or creating partnership or any business enterprise is to obtain or gain profits from the operations. Upon doing so, they should also recognize the sharing of profits and losses among the members or among the partners. There are instances that in the contract it's stated on how the profit and loss shall be distributed among the members in accordance with their agreement. In such cases wherein it is not indicated, the profits and losses shall be equally distributed among the partners. The last requisite is the legality of the object. The object to be recognized as an object of a partnership, it should be aligned to the or should be uh, lawful. When can we say an object is unlawful? It is when it is contrary to the law, to the morals, good customs, public order, and public policy. An example of unlawful act would be gambling or smuggling. Another example, a scenario would be, let's say, A enters into a contract with B and promises B to pay only when B uh, embezzles money from C. That is considered as a unlawful act, and therefore the law is recognized as void or ab initio. All for my report. Thank you so much, and once again, have a good day.